Hello, good morning, good afternoon, good evening, wherever you are. This is the Mission Mediation podcast. And can you imagine, we're already at our 10th episode. There's so much happening in the mediation space. I'm your host, Jonathan Rodrigues, and I'm joining you live today on the Mission Mediation podcast. I'm also a mediator based in Delhi. I'm your host, Jonathan Rodrigues. Sorry for that mishap. They're going to cut that through. We're having a few internet problems today. We're going to fix that very, very soon. Once again, thank you for your patience. We know we are a little delayed on this podcast episode, but we can't delay it anymore because we've got a very, very special guest joining us, Senior Advocate Sudhanshu Batra, of course, a senior mediator himself at the Supreme Court and the Delhi High Court, joining us today. It's such a pleasure to have him today on the podcast. This is, as I said, the 10th episode. We've had some fantastic guests talk to us about different aspects of mediation. We've spoken about mediation in the international context and, of course, also the Indian context. There is so much to dive into. Today's focus, though, is purely on confidentiality. We talk about the essentials of mediation, and one of the essentials of mediation is confidentiality. Now, that's easier said than done, right? And it's often misunderstood. There are a lot of myths surrounding what can be held confidential in mediation. How do mediators protect confidentiality? Is it the responsibility of the mediator or the mediation institute to actually protect confidentiality? And we want to dive into all those aspects because I think it's very crucial to understand that. In my experience, especially in the space of private mediation, one of the things that really gets people apprehensive about the process is the privacy and the confidentiality element kind of surrounding the process. And I want to kind of throw the mic open straight away to Mr. Batra and ask him, what is your initial, I would say, take on confidentiality in the mediation space?
Thanks, Jonathan, for organizing this whole episode. It's a pleasure to be with you always, and especially when we're in the field of mediation, which is so close to your heart and to a lot of us. Confidentiality, Jonathan, in mediation is indeed meant to act like a safety blanket. It gives parties the assurance that what they say will not go outside the room. And that is essential for honesty, candor, and the real dialogue. Confidentiality encourages candor and openness. Parties know that whatever they disclose, whether it's weaknesses in their case, their business interests, or personal emotions, this will not be later used against them in court. This security allows them to speak honestly, admit mistakes, and explore genuine solutions, which rarely happens once litigation begins. Confidentiality also protects negotiations from becoming evidence. Especially in pre-litigation mediation, no pleadings or affidavits are filed by the parties, as you're fully aware. So positions are not frozen. Confidentiality ensures that offers, concessions, or settlement terms or ideas cannot be quoted or misused if mediation does not succeed and the dispute proceeds to court. Confidentiality actually creates a very safe environment for creative problem solving. Parties can brainstorm solutions, may it be commercial, relational, or interest-based, without fear that if the proposals fail, it will not weaken their formal legal stance later. This safety net makes mediation a unique space where risk-free dialogue is possible, unlike the public scrutiny of litigation. It builds trust in the process, of course, and also with the mediator. Confidentiality is a promise that the mediator will not disclose who can they shuttle sensitive information strategically and bridge the gap. That's the mediator's role when he maintains, builds the trust, and creates that atmosphere of strategically trying to bridge the gap between the two parties. Of course, it preserves relationships. Many pre-litigation disputes involve ongoing relationships. As you know, there are family members involved, there are business partners involved, there are employers and employees involved. There are so many other relationships, which are not only family relationships or personal relationships, but even commercial relationships. Confidentiality, if maintained, can preserve that relationship, or at least stop further deterioration of a relationship. Confidentiality protects reputations and prevents unnecessary escalation, making it easier to maintain working ties even after resolution. Also, confidentiality prevents escalation and media or public exposure. As you know, court proceedings are quite public. So,
Yeah.
pre-litigation mediation, being confidential, shields sensitive disputes from media attention or reputational harm. Cases like the defamation case. I remember having done some of the matters, disputes where parties had sued each other for defamation.
Right.
Certainly, they would like this to be made public, but
Yeah.
mediation really works. The confidentiality process really works. So this privacy is essentially important in commercial and very high-profile cases. I recently had a very interesting dispute where the author of a book who had granted certain rights to the filmmaker had actually distorted, according to the author,
Yes.
the facts given in the book, and that she had sort of facing a lot of questions from the public as to how did you even write these facts. So she had to sort of explain to everybody that these are not the facts of my book, so they were distorted. So a defamation suit was filed, parties went into litigation, and the matter was referred to mediation. It was important that you maintain that confidentiality when you're trying to use this process to facilitate parties for a settlement. So, in short, I would say that confidentiality in pre-litigation mediation or mediation is unique because it offers a risk-free, reputation-safe, and trust-driven environment where parties can freely explore settlement without jeopardizing their legal rights if mediation doesn't work. It is this assurance that often makes parties attempt mediation before litigation, when the possibilities of resolution are much, much wider.
Yeah. Fantastic. And thank you so much, Mr. Batra, for laying that out in terms of what value does confidentiality bring to mediation, especially in private mediation, especially in pre-litigation private mediation, right? I think it's very essential for us to also remind the audience, many of whom would be lawyers, mediators, and also users, business folks are probably joining us, or people who are actually struggling with a dispute right now, who are considering exploring mediation, that mediation begins much before the actual process. It actually begins when either of the parties makes that first call to either the mediator or the mediation center and says they want to explore mediation. I remember working on a case many years ago where I was working with the mediation center. They reached out, and one of the first things they said to me, say 15, 20 minutes into the conversation, they said, I want to invite the other side to the mediation. That is for sure. I want to give it a try. But if at all they say no, this has to remain confidential. And how do you ensure that it remains confidential? So I of course said to them that from our side, from the mediation center's perspective, that will always remain confidential. We are not going to share this information with anyone. Just like I'm telling you today, I'm telling you the story, but I've not told you who it is, right? So it remains confidential. But from the other person's side, because I did invite party B, party A reached out to me, and I did reach out to party B. So party B does know that there was a request for mediation, right? Now that part, of course, it's not It's not something in our control as a mediation center or a mediator. But of course, when we write to party B, we do mention that this has, of course, been uh, shared with you in confidence, and this is, of course, a delicate matter. So I think confidentiality is such a huge thing. It's the first step of trust building in many aspects for users and lawyers exploring mediation. But thank you so much, Mr. Batra, for laying that out, because I think there is that academic element to confidentiality which sometimes is not very clearly understood by everyone. So when confidentiality is put out there as one of the principles, I guess, when mediation came to being as a profession, as a practice, one of the reasons we say confidentiality is such a huge element of mediation is that it allows parties to be honest. It allows them to be free. It allows them to be, just relaxed, and they have that space, that psychological safe space for them to share information with the other side in a joint session, and then with the mediator, specifically in that private session or what we call a caucus. There's another layer of confidentiality, multiple layers of confidentiality in the mediation. So the idea of having confidentiality gets us mediators excited that this will allow us to actually break down their positions, break down into why they are saying what they are saying, or why they're behaving how they're behaving, right? And we're hoping that we will be able to move them from positions to interest, from their kind of die hard kind of in ideologies in terms of how they want to get into the solution, to then moving them to something closer that can meet the other side. And we're expecting that to happen because it's confidential. And we say, be honest, be sincere, tell us what's going on, tell us what your real needs and interests are. But it's easier said than done, as you would agree with me, Mr. Batra, after mediating for so many years, both in the Delhi High Court and the Supreme Court mediation centers, that it's easier said than done. So uh, is it really, as a mediator, can you really get people to share stuff confidentially with you? And what's your process in getting them to open up to you and share that information, which is relevant to take the session forward?
Yeah, Jonathan, you're absolutely right. The whole idea of confidentiality is to build trust with the parties. And that gives them space to open up and be completely honest. Now, sometimes it's easy and sometimes it's not. So, it would be easy when, for instance, parties walk into the mediation room already aware of the ground rules. But that's not enough. The mediator needs to explain and reassure the parties the confidentiality protection right up front, at the opening statement stage, right in the beginning. And I think a lot of emphasis needs to be made at the opening stage on the aspect of confidentiality. And once you're able to communicate that in the manner that is most appropriate, the mediators, the parties start looking at the mediator as a person that they can trust. It's very difficult for people to open up. People will be very, very closed, and especially when there are disputes. So, if they trust the mediator, is his neutrality or her neutrality, and believe that the process is truly private, they tend to open up quickly. In such cases, the caucus session, as you rightly said, becomes very, very powerful, because parties are willing to put their real concerns and interests on the table without fear of it being used against them. And this can only happen when you build that trust of confidentiality, that we
Yes.
will not disclose anything that you don't want it to be disclosed. Now, this is a scenario where, it's easy when the parties are already aware of some ground rules on confidentiality, amongst the other aspects of the mediation process. But it's always not very easy. Parties are coming to you for the first time. They're coming to a stranger. It's not easy to straight away, feel what do they fear? So one thing I think what they fear is the information will be leaked. So parties worry that the disclosure will somehow slip into the joint session or later in court if the mediation remains unsuccessful. And the other is, I at least experienced that the power imbalance. If one party feels vulnerable, they might think that even the mediator could unconsciously favor the other party. It's quite natural, whether it's a commercial dispute or a personal dispute between, let's say, siblings or family members, or commercial disputes. When one party, a small supplier, will look at it differently. A multinational will feel that he's sitting on a higher bargaining power. He doesn't mind contesting. He doesn't mind spending money on litigation. He doesn't mind whatever the result would be. He's willing to take that risk. But so that power imbalance also creates sort of an obstacle or a barrier for the parties to straight away believe in confidentiality. So that is important for the mediator to interact with the party and create that atmosphere of trust. In some cases, I've seen that past experiences of the parties have also played a very major role.
Yeah.
Some parties have been burnt before. You say they've disclosed some information in negotiation or in the legal process, and it comes back to haunt them. This memory lingers. They feel that we've done it before. They used it against us. What's the assurance that they will not? Therefore, the process needs to be so carefully sort of put forward to the parties.
And if I can just come in there, Mr. Batra, I think when you say burnt before, people who have trusted maybe mediators, mediation centers in the past, and it has then gone out into once again into the public. I know this happens rarely, but it does happen once in a while in court and ex mediation centers where some mediators, I'm not saying all of them, and I need to be careful here, but you have instances, I've had lawyers come and say to me that the mediator has basically, asked us to push for a settlement, or else they're going to send a report back to the judge saying that we were being uncooperative or non-participative in the mediation. Now, to everyone listening in, by the way, the Delhi High Court came down very, very strongly on this many years ago and said that if the mediation fails, or rather if the mediation does not result in a resolution, then all that the mediator has got to do is write a simple message to the judge saying mediation failed. That's it. There's no more information shared with the judge. So that's the level of confidentiality that needs to be maintained and preserved in the mediation process. So when we talk about building trust, because it goes hand in hand with confidentiality, we expect parties to open up to us. But I'm so thankful for you to bring that up in terms of, sometimes we judge them in terms of why are they not responding, why they're not opening up, why they're not, kind of participating when we are asking them important questions that can lead to a resolution. And there's probably something, there's something there in the background which has caused them to be that way. I think I just want to be very thankful for you to bringing that up, and because that's an aspect that's hardly spoken about. What has been your experience, though? Have you had situations where I know that you have something to share with us? So, what has been your experience of kind of building the trust of parties?
Yeah, I'll come to that experience with I can relate to some of the cases that I had done. But before that, first of all, I just want to add, we never write that mediation failed, Jonathan. We always say mediation remained unsuccessful at this stage.
That's a better phrase, for sure.
To my mind, a mediation never fails. Parties have made some attempt. They've moved some steps forward, maybe not finally.
Agreed.
So our report, you're absolutely right. It's important that we inform the parties at the very outset and during the opening statement that there is confidentiality between the mediator and the court as well. The court, in case you go to court, the court can't summon the mediator to find out what transpired. The court has to deal with the matter as it comes, the facts, the evidence, the documents, and so on and so forth. So it should not create any prejudice in the mind of the judge for or against either of the parties. So we what is important. So on the whole, what I see, what is important is that there must be clarity on confidentiality right at the outset. Explain what confidentiality means, what are its limits, and why it exists. All these things, if you rattle off in an opening statement, they may not be absorbed. And what is important is that even after the opening statement, whether it's a joint session or a private section, what we call a caucus, you need to repeat this element of confidentiality, because that's how it's not easy. I mean, you go to a class, the lecturer or the teacher is delivering lectures. How much of what is delivered is absorbed? So you don't absorb everything in the opening statement. It's not necessary.
Right.
And it's very normal. The concentration power of a human being cannot be 100% all the time.
And it's also nerves. Early stages, you're nervous. Both parties have anxiety about the process. You're right. It's something that needs to be emphasized, needs to be consistently inserted into their minds throughout the process. I absolutely agree with you. Yeah.
For that, I think not only telling them in words, but you've got to demonstrate neutrality.
Yes.
So the mediator must show through words, through the tone, through body language, that the mediator is not aligned with either side. Even small cues make a lot of difference here. And it's also testing waters. Sometimes, it's about inviting the party to share something small in a caucus. Now, showing them how carefully you hold that information gives them that encouragement. And therefore, it encourages the mediator also to go deeper for a disclosure. Once they see that, if the information is safe, however small it may be, and it's respected, they're more likely to open up. It's not easy. So, mediation sessions don't conclude in one day. You have several sessions. And throughout those sessions, that element of confidentiality must be maintained. Now, therefore, I say that confidentiality is not a matter of words. It's not a rule on paper. It's an atmosphere that the mediator creates by demonstrating it. The parties feel that the words are honored and their vulnerabilities will not be exploited. That's when true interests come out, and that's when mediation works the best.
Mr. Batra, thank you so much for sharing that. If I can just come in here, because I got a nice example to kind of add on to what you just said about testing the waters, taking it easy to build trust, because we expect confidentiality instantly from parties. We expect them to, the moment they come into caucus with us, they should just share it and bear it all with us. And that's not true. That's not true, because they need time to trust us, even though they might have heard of our reputation, our resume. You're the person sitting in front of them. Because I remember doing this mediation many years ago when I was doing my master's in Scotland, and I was waiting for both the parties to come in. One party was there on time, so they were there at 9 a.m. in the morning, and the other one had not reached until like 9:15. And then they reached, and then they dropped me a message saying, "I've reached, but I'm in the lounge area. If you could please come and get me." And at that point of time, so I went down. I said, I didn't tell the second party that I'm going down to fetch the first party. I just went down. And when I went down, they said to me, they are just nervous. They've been actually here for the last 1 hour, but they're nervous. So they need some more time, because she wanted one of her best friends to accompany her in the mediation. It was a very small civil case dispute that they were mediating. So she just said that she wanted her best friend to be with her while she was negotiating this deal, right? And I said, that's okay. So I said, by what time do you think she's going to be here? And she said, in the next 20, 25 minutes, she'll be here. And I said, please don't tell them up there. Just pretend like I'm not here yet. And at that point of time, I said, that's fine. We'll just say that, I'll come back to party A and I'll say that if he wants to have a coffee or go to the washroom or make a call, we're just going to be a bit delayed. And that was important to them. That was important to them but that was that first moment of trust building, right? Confidentiality. It had nothing to do even with the case. It was just to build that trust with me. And I thought that was, when you said this now, I'm thinking about that moment then, and I'm like, this was not even about the case, and you're testing waters so early on. I absolutely love that very good tip that you've shared with all mediators today and all lawyers as well, that go slow with it, earn that trust. I think that's a brilliant takeaway. So yes, back to you.
Jonathan, I've also experienced, sometimes after the joint session has gone on for very long, and we decide, okay, we'll continue on the next day, that's suitable to parties.
Yeah.
And you do indicate, I've done it myself, that next time we'll have a caucus. Mm-hmm. So one of them immediately said, would you like to speak to me first or the other side? So I said, well, we'll take a call together. And they said, okay, no, I just want to know, in case you want to speak to the other side, then I will not come for that session. I can come when you call me later. So to which my answer has always been, we would prefer if both parties are present, even if we have a separate session, because the parties realize how long you're spending with the other party.
Right.
And it gives them the confidence, because you've got to spend more or less the same time. And if you don't spend the same time, sometimes it's not required.
Yeah.
You can sort of tell them that it's important for me to spend more time because we want to work on a solution. And, so make it sound as if, there's complete confidentiality in what you're doing. Don't tell the parties, okay, on one day we'll meet one party and the other day we'll meet the other party. That doesn't work, because they might start thinking a lot. In court, when the judge says something, just as an act to gather information or to understand the issue, we'll make a statement or give a prima facie view. Now, that may not be the final view of the judge, but the parties go home and carry it with them till the next date of hearing. And
Yes.
It disturbs them. So it's important that the parties are always present. You were asking me about my experience, about sometimes, confidentiality disclosure can also be very, very sensitive. I remember there was a family dispute between two brothers. In the caucus session, the younger brother made a disclosure. You know what the business they were doing? They were running a chain of retail shops. And emotions were very high. The two brothers had fallen apart. Imagine they've grown together, they've studied the same school, they lived in the same family, and suddenly there are undercurrents. And emotions are naturally very high. There is a dispute. And in the caucus, the younger brother made a disclosure to me as a mediator. At first, it was very damaging to his position. He said, I have taken a large personal loan against one of the stores without consulting my elder brother. Okay. And he says, because the tempers were high, emotions were high, he says, I don't care if this comes out. In fact, please tell my brother directly. I'd like to see his face. I'd like to see the reaction. Now, he's given me some information which I think should be confidential, but he wants me to disclose it. Now, the disclosure is also important, right? The disclosure is important. He's insisting that you disclose it. So I sort of had a chat with him, and I said, okay, let us try and reflect as to what is going to be the consequences. I heard you said you've taken loan. And what would be the consequences if I put this on the table? How do you think your brother will react? and try to put him into a scenario where he says, I want to see his reaction. You ask him, how do you think he'll react? How might it affect your chances of a settlement? Both of you have come for settlement, right? And both of you want a resolution. So how do you think that will affect the chances of a resolution? Now, this chat, as we were having, it made him think. And he says, okay, I think you're right. But I want you to disclose this. It's important. Now, it was important because ultimately a resolution must be complete. You can't hide such an information. So he said, he asked me to, he says, now express this entire disclosure as a matter of concern for transparency. You see how he himself came out with this idea. It wasn't mine. I would have probably done it differently, but he himself came up with this idea. And that is only when I asked him to reflect as to how his brother would react. And do you think this mediation will end up in a resolution? You think you're going to find a solution? So that made a difference. And then when the elder brother, I had a separate session with him again. And I very strategically and very softly, minding my tone, minding the words that I use, I disclosed this fact to him. And I said, he wanted to be honest because he says that he wants to go in for a resolution. He wants to be honest. And this is the problem. Now, obviously, the elder brother took that as a big surprise. At least he showed it to me, but I could read it that he had suspected that this has happened.
Yeah.
He was already suspecting. Then he says, interestingly, he said, I'm quite happy that he's been honest because I'd rather deal with the truth than keep guessing. So that was the turning point. And eventually, the mediation was successful. Both the brothers decided to rearrange their business. The business was rearranged. And they said, okay, let's put boundaries. Since it's a personal loan, some part of it you'll have to chip in. And the younger brother agreed. And a resolution happened. So what you disclose is one thing. How you disclose when the parties are telling you to disclose is another matter altogether. So these are some of the very interesting experiences one has had. There's so many vast disputes that fortunately I've facilitated. But ultimately, it was the party's call. They had to take the call. When I said, do you want me to disclose? Then he realized that, okay, it's important to disclose, but do it as a matter of concern for transparency.
So the right intention behind it, right there, that was crucial. But I want to kind of just pinpoint this to everyone watching this episode, that in that little action of yours to reach out to him with an open-ended question and ask him again to just check in whether he wanted you to relay this to the other side, you not only made sure that you were preserving confidentiality, but you also made sure you were preserving neutrality, because tomorrow you don't want to be holding the burden of passing on a message which is detrimental to him. You gave him the option to make that decision once again. Yes, he says yes, you do go ahead and relay that information, but with a different context. So it's still voluntary, it's still self-determined in nature, it's still neutral. So you kind of, in that one action, kind of held all the principles of mediation together. And I think that's a wonderful example, once again, of showing how the mediator can safeguard those principles of mediation, even though at that instant the parties are not thinking clearly about their interest.
Correct.
Absolutely. Do you I know when we talk about this amongst our circles as mediators, you'll always have some mediators will pop up and say, but were you taking his side? He said to reveal it. Why didn't you just reveal it just straight away? I mean, were you kind of being biased? Were you looking out for him? And then, I always say that it is our duty as mediators to look out for both parties. to look out for both of them. That's neutrality. I think you're mistaking neutrality with biasness. They're two different things. And when you're looking out for both sides, and preserving confidentiality for both sides, I think that's neutrality. But I wonder whether you have had those kind of conversations with others in the profession and industry about confidentiality and what it means to be kind of making sure that you are safeguarding the interest of both parties.
Yeah, we've had this, Jonathan, a number of times we feel that this may not be in the interest of the parties, but the party feels that's important for him or her. The call is of the parties. Please understand that mediation isn't about winning or losing a case. It's about making informed choices. If a party insists on disclosure, after reflection, the mediator respects that autonomy. The safeguard is in the preparation, helping the party weigh the consequences, explore alternative ways of saying it, and ensuring the disclosure is framed constructively. So the responsibility is actually lies in the process, Jonathan, not in the outcome.
Absolutely, it is in the process, and we talk about the three kind of elements that make mediation successful. We talk about process satisfaction, psychological satisfaction, and outcome satisfaction. And confidentiality, I think, really comes in that place of both process satisfaction and psychological satisfaction, which is so crucial to a mediation session. I'm not sure whether you can hear any background music. That's not part of the Mission Mediation podcast. For those of you who are joining live, please say hello. Tell us where you're joining us from. This is, of course, the 10th episode. We have senior advocate Mr. Sudhanshu Batra on. This has been a fantastic conversation so far. We're diving deep into confidentiality, which sometimes mediators finish speaking in 30 seconds. When we do opening statements, we do 30 seconds about confidentiality and we are moved on to something else. But look at this. Imagine we spend so much time talking to parties about confidentiality. We might actually be able to convince them of mediation and explore it further. Mr. Batra, I just shared with you about how do you take in information that's shared with you, and how do you take it to the other side. And you've got to be cautious and careful about what you're taking to the other side, right? Even though the parties have given you full license to go and take it to the other side. Now let's look into another scenario, Mr. Batra, if you may. There are situations where parties come up to you and share something very, very crucial to resolution, to finding a solution, and it's very important. But they'll say to you after sharing that information with you, which is very private, which surprises you and sometimes stuns you as well as a mediator, after having mediated for so many hours. And it's probably weeks and that you've been mediating. It's very intense, very emotional, so many facts, so many complexities with technicalities of the mediation. And then in the end, somehow the party and the lawyer finds trust in you and shares something very confidential. And then they say, but Mr. Batra, you got to keep this to yourself. You can't share it with the other side. This is very confidential. But you know that if there's a way to share it, it can actually find a resolution. In that instance, as a mediator, how do you handle that moment when you face a situation like that? I'm going to keep it very open-ended for you.
Jonathan, what you're saying is absolutely right. And we see that a lot in the process that we use for helping the parties or facilitating them. Mediator's role in that scenario is to transform that disclosure from a weapon to a stepping stone. It's not about hiding or exposing, but about ensuring that even tough truths are shared in a way that keeps the door to resolution open. I often say this is a dance of information. Parties will often share some things in caucus that are extremely valuable for the process, but not for disclosure. It may be valuable for the process, but not for the disclosure. Here, confidentiality comes in. Offers that are once on the table are withdrawn. The bottom line is that they must not be exposed, or the threshold, they might stretch it if conditions are met. They've created a threshold and they might extend that if their condition is. I'll give you an example. There was a dispute between a hospital and the family of a patient who died. And the allegation was negligence, this, that, and so many other things. And they're demanding money, obviously. And their expectation was huge. They really wanted a lot of money. Now, the hospital knew that it can fight litigation. It's got the money to fight litigation. But they would not, I did not disclose the demand. They demanded a huge amount. And I said, if I disclose this amount to them, I might get stuck and I can't take this forward. So what I thought of doing was to find out in confidence from the party that what is important for them. Is it the money, or is it an acknowledgement of something that went wrong? Something that they never expected from a hospital of repute. So in that process, of course, again, the emotions were high. The patient had died. Okay. So the family came up and said, I think what's important is that they realized that money cannot get that person alive again. The person is gone. But they said, what is important to us is they must acknowledge that what has happened is wrong and they must apologize. We are willing to look at the number that we've quoted differently. See, the moment they said that, I felt that now it is important for them. It is important for them to share this in confidence with me, that what they were looking for was an acknowledgement and an apology. They wouldn't admit it in front of the representatives of the hospital. No way. Now, I couldn't straight away disclose this. If I disclosed this straight away, what would have happened? Why should we say? Why should we admit? Suppose this doesn't work, this is going to be used against us. Okay. Now, they'll be very, very careful. But one interacted with them in such a manner that made them realize that actually, if you really want the number down, then let's do a reality check. And that reality check made them realize, and they did tell me in confidence, yes, it was our fault, but please don't tell the other side. So I said, all right, without admitting blatantly your fault, are you willing to acknowledge that this ought not to have happened, and then in future you will take care? Because giving an example of a situation where I had a mediation similar to this, and I said, in one case they acknowledged. Okay? So you give hypothetical examples of other instances, and you tell them, and they said, okay. Eventually, we had a joint session where they admitted. They admitted in the sense they acknowledged. They acknowledged the fact that, all right, this shouldn't have happened. Not admitted, because admission is something which would hurt them, which would hurt them, completely. So they acknowledged that, yes, this shouldn't have happened. We should have been a little more careful. But this was not necessarily the cause. But the point is that we sincerely apologize for what has happened, and we cannot undo what has already happened. Eventually, the number came to the ceiling that the hospital had shared with me, that up to this much they'll be able to agree. And the settlement was arrived at. But it's not necessary. Settlements in these cases are not necessary to arrive. If it doesn't arrive, it doesn't matter. At least you maintain that confidentiality, you maintain that trust, and then take the parties forward. Tell them to move. They can't get stuck at their positions. And I must say that the family did come up with this and started saying that, for us, it matters more. At least in future, they shouldn't create the situation that somebody else is affected by it. So the settlement was...
There's a bigger picture to it. There's a bigger picture to it in terms of what they're looking at. But once again, so fascinating in terms of how you get to the real interests, the real needs, and how you built their trust for you to, how you earned their trust so that they could share that information with you and then trust you to use it the right way, right? It's one thing about sharing that information, but it's also the trust in you as a mediator to use that intel the right way. They trust you to guide them in a way they can use that intel and share it with the other person to find a resolution. That's so important. We talk about confidentiality so loosely in mediation as if it's just, oh, you can share anything with me and I won't share it with the other person. It's said so blatantly, but to share it this way, when you share it this way, parties are willing to kind of use you as a mediator, use your skill as that, almost like the supercomputer holding all that intel and then making the right move, helping and then guiding them towards using that intelligence, using the information towards resolution is such a unspoken aspect of confidentiality. And once again, Mr. Batra, you're bringing up some really powerful insights today. So I really, really appreciate that. I'm sorry, I interrupted you. Please go ahead.
No, I said, the point is that what is important is that even if you have to disclose something, it is important to take the process forward. It is important to disclose, but do it in a manner that the confidentiality is not looked upon as breached. For instance, with the hospital, I said, suppose the family prioritized recognition of what happened. Could that create room on the financial side? Could that create a room on the financial side? Suppose the family gives this priority of the recognition of what happened. What they were looking for was recognition. If the hospital was willing to make that non-monetary gesture or concession, perhaps we would be closer to a settlement. And that's what you're looking for, right? So you put it like this, and confidentiality is not breached, but you disclose it in a manner that helps parties to come up with their ultimate resolution option, which would be, all right, we will do it. Let's close it. Nobody wants to go into litigation, Jonathan. In today's world, litigation is something which everybody wants to avoid. It's a rare case, honestly. Rare cases are there where parties, want to test it out. But by and large, that we come to know. Then we feel that there's no element of settlement. Confidentiality or no confidentiality, then it won't work.
Yeah, absolutely.
But so that's why I said it's not important about who wins or who loses. It's the process that you must have faith in that you're taking along.
Yeah, and I just want to bring this up once again because you're really demonstrating what a private mediator does, a seasoned, experienced, committed private mediator does. If you see, and if anyone who's watching in this and who will watch this in the future, and who's probably watching this for a lesson in confidentiality in mediation, this is what it means to hustle as a mediator. This is what it means to actually collaborate. I don't want to once again just be bashing up, our scenarios in court and next mediations because, of course, we have a limitation of time and resources there. But in court and next mediation, sometimes you don't really have the time to get into the collaboration mode. Collaboration requires parties to actually come out and share their real interest and share that real information, which mediators can then use in that confidential setting to take forward towards a resolution. right? Collaboration, it's easier said than done, but for collaboration to exist, parties need to start sharing that information with you. And that's the only way to do that is if they trust you to use it the right way, which I think is just once again such a huge aspect of um, private mediation practice and confidentiality.
Jonathan, it's very tempting for a mediator to immediately disclose this. You
Yeah,
would think that in
absolutely.
the next session I'll immediately close it.
Yeah, I've got it. It's a eureka moment.
Because the mediator is also running after the outcome. You don't run after the outcome. That's not the skill of a mediator. So the temptation is there, but you've got to hold yourself and give space to the parties to absorb.
Yeah, I mean, it's fascinating in terms of how much. Sorry.
Yeah. The art also lies in demonstrating patience.
Yes.
When you give them space, you've got to demonstrate that patience. And for that, you've got to be patient yourself. It's easier said than done. But I'm telling you, it's a tough call, but it certainly helps. It works. This is my personal experience. It works.
Patience, another huge aspect of confidentiality. There's so much we're diving deep into here. I mean, there's amazing. You started this off by saying, talking about, of course, the academics behind confidential and what it means, and you brought up this whole point of course, testing the waters and building trust easy and not rushing into gathering information and expecting parties to be just opening up to you. You then kind of we moved into navigating the space where what do you do with information that you have license to share, but according to your wisdom and prudence, it's not the right time to share, not the right way to share it. And then we went into what do you do with information that you have no license to share, but you could, even though the parties are saying no, don't share it, you can go back to them and probably explore with them what could be the potential outcomes if you do share it. And the final choice is theirs. The final choice is theirs. So wow, this has been a brilliant learning lesson on confidentiality in mediation.
So I would say that a mediator is not a messenger of information.
Yeah,
Not simply a messenger, courier service. One message comes and deliver it.
yeah,
Deliver it and bring it back. That's
Yeah.
not the way. That's not the way the process works.
yeah. And sometimes it feels like that for a lot of people. When it's done so mechanically. Okay, I got like 5 points I need to share on the other side, and you take those 5 points and you go on the other side. I think what you say there once again, and maybe we could spend the last few minutes on this, Mr. Batra, that the whole aspect of patience, of taking a step back. You've got some intelligence, you've got some information that's been passed on to you. For you to take a step back and you yourself analyze that and assess that and evaluate that piece of information in terms of how you think you want to use that going forward. I think that's such a crucial aspect. And just don't take it for granted. Oh, they've given me the license to use it. That's it. I'm just going to go with it. Because they're looking up to you as a mediator to kind of steer them towards resolution. So I love what you said in the start, where you said, does that information help you move towards resolution or not? I think that's such a crucial aspect. But yeah, maybe your final thoughts on this before we wrap up today.
So I would say, confidential information is not a burden; it's a privilege.
Yes.
The parties are sharing something with you; it's a privilege. So the mediator's craft is to honor this seal of confidentiality while still making use of its wisdom, of the mediator's wisdom. Exact words need not be shared, but what needs to be shared is the direction, the possibilities, the pathway. And that's often enough to move parties from deadlock to resolution. I would say that's how confidential information should be used.
Love that. You've given us another headline. Confidentiality is not a burden, it's a privilege. Absolutely love that sentence. And that's the skill, that's the thrill for a mediator to own that responsibility and to own that opportunity to actually help parties move towards resolution. This has been a thorough lesson in confidentiality. Thanks to senior advocate and mediator, Mr. Sudhanshu Batra. Thank you for joining us on episode 10 of the Mission Mediation podcast. This has, of course, kickstarted a fantastic series of learnings of the essentials of mediation, and we are so very happy to have you on this episode. Thank you so much, sir, for joining us.
You, and let me close by saying, Jonathan, thank you for having me. One of your episodes. I've seen some of the past episodes. They've really been very enlightening. And it's always a very, very a learning experience, even for seasoned mediators or trained mediators or long-standing mediators, to go back and reflect, attend these kind of sessions. I mean, today is what I shared, but there are lots of people, lots of good people who are doing excellent job throughout the country. And let's take this mediation movement really forward. It deserves to be taken.
Absolutely. Thank you for making it special. And for all of you joining us, thank you very much for joining us. Please look out at the other episodes as well. There's so much to learn from in this space. And reach out to us if you have any questions on mediation. Thank you. Take care. See you on the next one.
Bye-bye.